Ready, start. In our considered view, both the grounds to decline the relief of specific performance are not sustainable. Because while deciding issue A within bracket supra bracket close, we have already held that High Court erred in law by setting aside finding of fact returned by the first appellate court that D-1 and D-2 were paid additional rupees 1,95,000, which they acknowledged by making an endorsement on the back of the agreement. In our view, acceptance of additional money not only signified waiver of the right to forfeit advance money slash consideration but also acknowledged subsistence of the agreement. Hence, High Court's conclusion that plaintiff had set up a false case of additional payment is unsustainable and therefore cannot be a ground to decline discretionary relief of specific performance. Insofar as plaintiff's case of him being in possession of suit scheduled property is concerned, the same was not accepted on the ground that there was no recital in the agreement regarding handing over of possession, but that by itself would not be sufficient to hold that the plaintiff made a false claim of being in possession. A claim, if not proved, does not make it false. A statement is false when its maker knows the same is incorrect. Otherwise, also, the plaintiff stands to gain nothing substantial by claiming possession over the suit scheduled property in a suit for a specific performance, inasmuch as a decree of specific performance would ultimately entitle him to possession. In the instant case, there is evidence on record that the Tehsildar had reported regarding possession of the plaintiff over the suit's property, though that report was subject to final adjudication in the suit. In such circumstances, merely because plaintiff's claim that property was in his possession was not accepted, the relief of specific performance cannot be declined, particularly when the plaintiff had already paid over 90% of the agreed consideration and paid additional amount also as demanded by D-1 and D-2. Further, D-3 was a related party of D-1 and D-2 and therefore not a bona fide purchaser. We are therefore of the firm view that this was not a fit case where discretionary relief of specific performance should have been denied. For the aforesaid reasons, we are of the considered view that the High Court erred in law by interfering with the decree of specific performance passed by the first appellate court. These appeals are therefore allowed. The judgment and decrees of the High Court is/are set aside and that of the first appellate court is/are restored. As it is not clear from the record before us as to whether the plaintiff has deposited the balance amount of rupees 10,000 for execution of the sale deed in terms of order 20th Rule 12A of CPC, we deem it appropriate to direct that the plaintiff appellant shall deposit the balance amount, if not deposited already, in the execution court within a period of 1 month from today. Parties to bear their own costs, pending applications, if any, shall stand disposed of.